All right, well, let's make a start if that's okay. Thank you for joining. Welcome to the second in our two-part series on capacity and education. The first webinar that we held was on the 23rd of May, and that was entitled Exploring Issues with Access to Education and How to Address Them in Court of Protection Proceedings. And a recording of that webinar is on our website. And my three colleagues on that occasion provided an overview of the planning around education provision. So they talked about education, health and care plans. They provided an overview of the tribunal systems, which or the tribunal system rather, for appeals, which might have been fresh information for lawyers who predominantly work in the Court of Protection. And they then considered what steps could be taken within Court of Protection proceedings for 16 to 25-year-olds who had an EHC plan, and then considered what steps could be taken if they didn't have a plan but may benefit from one. And then colleagues provided examples on how to progress education matters within Court of Protection proceedings. So that was really looking at education within the COP, and today is sort of the reverse. So we're looking at capacity issues within education proceedings. So again, this webinar will be recorded. You will receive an email hyperlinking to the recording, and you'll get the slides, and the slides contain some hyperlinks themselves as well. And so this issue, like the previous issue, is rather complex. And just a warning that this webinar doesn't seek to be a complete guide to these complex areas of law, but really just to highlight the salient issues about capacity and about the Court of Protection, predominantly for education lawyers. So we're going to have three presentations. Firstly, we're going to hear from my colleague Asma Nizami, who will introduce herself. And she's going to be talking about capacity and what the Court of Protection can do with regard to a young person's education. And then she's going to hand over to Louise Price, who will explain capacity issues within the first tier tribunal, special educational needs and disability. And then she will hand back over to me, and I'm going to be giving a very short presentation on deprivation of liberty issues that arise, and then saying a few words about restraints and restrictive practices in schools. So without further ado, I will hand over to Asma. Thank you.
Thanks, Oliver. So hello, everyone. My name is Asma, and I'm a member of the Court of Protection, Immigration and Education teams here at Doughty Street. I'm regularly instructed to represent people in the Court of Protection who have EHCPs, and even if they don't have EHCPs, sometimes issues to do with their education arise in the Court of Protection proceedings. Could we have the first slide, please? And the next one. Thank you very much. So, as a general point, I should start off by saying that capacity issues, of course, can arise in any area of law. It's not just education clients that will have capacity issues. That almost goes without saying. And it's good to think about spotting capacity issues amongst your clients, whichever jurisdiction you're practicing in. I would suggest that if people haven't already, they take some time to have a look at the practice note produced by the Law Society called Working with Clients Who May Lack Mental Capacity, and it's dated June 2023, so it's about a year old. And that has some quite useful guidance for solicitors who have concerns about their clients' capacity to conduct proceedings. So in terms of education in the context of cases that you may be coming across, as you know, Section 20 of the Children and Families Act 2014 defines a child or young person as having special educational needs if he or she has a learning difficulty or disability which calls for special educational provision. This does not mean automatically that the child or young person will lack capacity to make a particular decision. Their diagnosis, though, may be relevant to capacity. So if you have a client who is someone, for example, who's been diagnosed with autism, you cannot assume that that will mean that they lack capacity to conduct proceedings or that they lack capacity to make decisions about their education. Further investigation and analysis will most likely be required. And I did want to start off by pointing you to some helpful case law that some people don't know about. And it's the third bullet point here, that if someone has a diagnosis, that may of course be relevant to whether or not they have capacity in a particular area, but a formal diagnosis is not actually required to establish that a person lacks capacity to make a particular decision. So in the case of ST, which I've referred to in the third bullet points, Mrs. Justice Roberts confirmed earlier case law, which said that there is no requirement for the court to be able to precisely formulate the underlying conditions which constitute the impairment of the mind or brain. And in that particular case, ST did not suffer from any psychological or psychiatric disorder, but the court still found that ST's inability to accept the medical reality of her situation and to accept that doctors may be giving her accurate information was the result of an impairment of or a disturbance in the functioning of her mind or brain. And so the court went on to find that she lacked capacity to make decisions about her medical treatment. Even if you have a diagnosis, though, that does not mean that it follows, as I said, that there is an impairment of or a disturbance in the functioning of the mind or brain, which makes the person involved unable to make a decision. And that was confirmed in the case of Re Z, which I've referred to in the fourth bullet point. So what I'm essentially getting at here is that you can't make any assumptions. Each case will need to be assessed and analysed on its own facts. And you may need to give some thought to exploring things further before you take the necessary steps. And the starting point, whenever you're considering capacity issues, is of course the Mental Capacity Act 2005. So I'd suggest, if you haven't looked at that before, and I'm not assuming anything because we have a range of people attending today, please do have a look at that. And also you might want to cast your eyes on the Code of Practice, which I have quoted or referred to in my fifth bullet point. Next slide, please. And just to flag this up, because this is something that often gets overlooked. So the Court of Protection, which I'll come on to in a minute, applies to or has jurisdiction over those who are 16 plus, so 16-year-olds plus. If the person concerned, P, lacks capacity within the meaning of the MCA 2005. And it's useful to note that if an individual is 16 or over, professionals will presume that they have capacity to make a particular decision unless the presumption about their capacity is rebutted. And normally, the way that the presumption would be rebutted is by way of expert evidence that demonstrates that they lack capacity. And just to flag up that Schedule A1 of the Mental Capacity Act, which relates to standard authorizations, does not apply to those under 18. All right, next slide, please. So in terms of the Mental Capacity Act, as I said, it's really important when you're considering capacity issues. It was intended as a consolidating or clarifying document. And you can see that from the explanatory notes, which I've quoted. The MCA replaces other legislation that was in force previously, including the Mental Health Act 1983, parts of that, Part 7 of the Mental Health Act 1983, and the whole of the Enduring Powers of Attorney Act 1985. So it's supposed to be a codified codifying act that is really meant to be a one-stop shop when it comes to dealing with capacity issues. Next slide, please. And there are some basic principles in the MCA, which may be familiar to some. And if you look at section 1, they are set out there. The first is that a person must be assumed to have capacity unless it is established that they lack capacity. That's at section 1(2). As I said, just because someone has a diagnosis of autism or Down syndrome, for example, it cannot be assumed that they lack capacity in a particular domain. The second principle is that a person is not to be treated as being unable to make a decision unless all practicable steps to help them to make the decision have been taken without success. So this might mean, for example, providing a person with additional support during a capacity assessment, using particular communication devices, or making sure that they are supported by a particular support worker who they know well and who knows them well, making sure that the capacity assessment takes place at a particular time of day, which might maximize their ability to engage and participate. And it could be, for example, giving someone more time to answer questions than might ordinarily be given to another person. The next principle, which is at section 1(4), is that a person is not to be treated as being unable to make a decision merely because they are making an unwise decision. So this is relatively straightforward in a way, but it can be something that crops up in complex cases. In the context of care and treatment, someone may, for example, be refusing to have a particular procedure done, and that may seem like a decision that they're making without capacity to make that particular decision, but it could also be an unwise decision, and sometimes unpicking that can be complex and may be what the court is required to do in a particular case. The next principle is something that I'll come back to, and that's to do with best interests. And so this is at section 1(5). It just reminds us that any decision that's made under the Mental Capacity Act for or on behalf of a person who lacks capacity must be done in their best interest. This is a really important concept. And then section 1(6) is the least restrictive principle. So it just reminds us that when a decision is being made in respect of a P, the subject of proceedings, everyone must be thinking about whether the decision is the least restrictive option. Is there another way? Is there a less restrictive way of achieving the same outcome? Does a decision need to be made at all? It's often something that needs to be given some quite careful thought. And the other point I just make in relation to this is that what is in someone's best interests may not always be the least restrictive option. So there can be a tension there. Next slide, please. The case of JB was heard in the Supreme Court a few years ago now, and it was the first time that the Supreme Court grappled with what it means to lack capacity under the Mental Capacity Act. If you haven't read it already, I would suggest that you do. It was a case where the subject of proceedings, JB, was someone about whom there were concerns in relation to sexual activity, and the court had to determine whether JB had capacity to engage in sexual relations. Obviously, there was expert evidence that had been dealt with in the lower courts. And Lord Stevens, whose judgment is at paragraph 65 to 79, summarized the relevant case law and, in summary, set out these questions. And this is the correct approach to assessing capacity under the MCA. This is consistent with sections 1 to 3 of the MCA. So the first question that he says that we need to ask is P, the subject of proceedings, unable to make a decision for himself in relation to the matter? That's the first question. And the second question only applies if P is unable to make the decision. That is the inability to make a decision because of an impairment of or a disturbance in the functioning of the mind or brain. And this guidance from Lord Stevens was quite a shock to some because of the way that he ordered the questions. Up until that point, the approach to capacity was slightly different, and as a result of this judgment, standard forms have had to be rewritten to make sure that professionals are approaching capacity in the right order and asking themselves the right question. But I thought that I would just provide this slide here so that you have a summary on one page of the correct approach. So let's move on to the next slide, please. Now, you might think, where do we go from what Lord Stevens said in JB? And the starting point is still Section 2.1 of the Mental Capacity Act. And Lord Stevens did say that Section 2.1 remains the core determinative provision. Section 2.1 says a person lacks capacity in relation to a matter if at the material time he is unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain. And so this could be because of a learning disability, could be because of a traumatic brain injury, or confusion, shock because of tiredness, drugs, or a coma, for example. And Section 2.1 reminds us that there needs to be a causative nexus. So there needs to be a link between the inability to make a decision and the mental disturbance or impairment. Moving on to the next slide, please. Some things to bear in mind. First is that capacity is, of course, time-specific and decision-specific. So if you are looking into P's capacity to conduct proceedings, that does not inform you about whether or not P has capacity to make decisions about marriage or their care. So you need, what's being analysed at a particular time is the particular transaction, the particular matter. And it's important not to try and confuse things. And of course, there has been a lot of case law where P may lack capacity to make decisions about the subject matter of proceedings. So, for example, if there's a case involving medical treatment, P might have been assessed as lacking capacity to make those decisions, but P could have capacity to conduct litigation and therefore wouldn't require a litigation friend. So just bear that in mind. The other thing to flag up is what is said at Section 2.2 of the Mental Capacity Act, and it reminds us that an impairment of P's mind or brain can be temporary. It need not be permanent. So, of course, something like dementia would be a permanent and progressive situation. But if someone is in shock or in a coma, that might be seen as a temporary situation. The other point is that one cannot make assumptions based on age, appearance, or aspects of P's behavior. So do not make assumptions, as I said previously. And the other point here is that standard of proof when we're considering whether or not P has capacity is the balance of probabilities, which of course is it more likely than not? And the other point here is that capacity may, of course, fluctuate. So it may be that P has a condition, which means that their capacity fluctuates as a part of their condition. So, for example, something like borderline personality disorder, previously known as emotionally unstable personality disorder, could cause periods of heightened emotion or behavioral outbursts, at which time P could lack capacity in relation to a particular matter, but at other times when P is calm and not heightened, they might be perfectly able to make their own decisions in a capacitous way. Or it could be, the other situation where capacity may fluctuate is that it could be because of their health, that their capacity is fluctuating. So I've had clients who, for example, when they have urinary tract infections, that could potentially mean that their behavior is more heightened than it normally would be. Moving on to the next slide. So inability to make a decision is dealt with at Section 3. And this, of course, links back to what Lord Stevens said in JB about P being unable to make a decision. And when you're looking at whether or not P is unable to make a decision, what you're asking is P able to understand the information relevant to the decision? Can P retain that information? Can P use or weigh the information as part of the process of making the decision? Or is P able to communicate his decision, whether that's by talking, using sign language, or any other means of communication that P may use? And if one of those elements, one of these tests is not satisfied, then P will be unable to make a decision. Moving on to the next slide, please. Just a word on relevant information. So you'll note that when I was talking about Section 3, we saw that the statute refers to being able to understand the information relevant to the decision. So what is relevant information, you may be asking? This will vary depending on the particular decision that's being considered. So the relevant information for a decision about whether to have contact with someone or whether to live in a particular place will be different. The other area, of course, that is particularly relevant to today is decisions about education will involve particular relevant information, and that relevant information will be very different to the relevant information about marriage. So it's very important to identify what the particular decision is that you are concerned with, and also to identify what the relevant information will be. And in JB, Lord Stevens did say that the relevant information will depend on the specific factual circumstances of the case. And just to flag up that the relevant information will include the reasonably foreseeable consequences of the decision or the failure to make the decision. So let's move on to the next slide, please. I can whiz through these slides because I touched on this last time, and I don't want to repeat myself, but this is just to give you the reference. This is the case of GP, where the Court of Protection dealt with a case in which P was found to lack capacity to make decisions about his education, and also to request a needs assessment to trigger the process for obtaining an EHC plan. And I've just in these slides given you the relevant information in relation to a decision to request an assessment of need, and also to make decisions about education. So it's just worth having those at your fingertips in case it comes up in one of your cases. If we move on to the next slide, please. Yes, so this is again from the same case, from the case of GP at paragraph 34, where the judge summarized the relevant information when it comes to capacity to make decisions about education. Moving on to the next slide, please. I apologize for the sound. I apologize. Moving on to best interests. So, yes, thank you very much. This is just to flag up section 4. So as I said earlier, any decision that's made on behalf of or for a person who lacks mental capacity has to be made in their best interests. And section 4 of the Mental Capacity Act tells us how a court should, or the Court of Protection should determine P's best interests. And I'm not going to go through all of section 4 because it's laid out for you. But in summary, the court needs to try and involve them as much as possible in a decision about them. And the other point is that there is no actual definition of best interests in the legislation, but we have set out for us a series of different factors that should be taken into account, including P's wishes and feelings, and their beliefs and values, if they were able to make a capacitous decision. So moving on to the next slide, please. In relation to capacity to conduct proceedings, because this is, of course, an area that will be relevant if you are dealing with education proceedings. The case of Masterman and Lister is really the key case, but you'll note from the date, it's from before the Mental Capacity Act came into force. And it is still, though, useful guidance. Paragraph 75 is really instructive. It tells us that what we as professionals need to be considering is, does our client have the ability to understand the issues on which consent or a decision is likely in order to pursue a particular claim? If your client has capacity to understand that which he needs to understand in order to pursue or defend a claim, then it's likely that they would have capacity to conduct the proceedings. And on to the next slide, please.
Asma, I just, sorry to interrupt, really huge apologies. In light of the time, I just wonder whether it would be worth going to the powers of the Court of Protection, and just to outline that. I think Louise might be touching on conducting proceedings as well, capacity in education. Is that all right? And then
that's absolutely fine. I'll move on. Thank you.
Yeah.
In any event, people will have the slides so they can read them in their own time. I'll move on to the jurisdiction of the COP. So if we could move on to that slide, please. I'll start talking in any event. It's the next slide after that. It's this one. Thank you very much. So in terms of the Court of Protection, people are often a bit unsure about what the Court of Protection actually is. It's a creature of statute. It was created by the Mental Capacity Act. Section 45 is the relevant section. And the Court of Protection makes best interest decisions about those who do not have capacity as defined in the MCA. And just to say that there are some decisions which are excluded. So the Court of Protection cannot make decisions about certain family matters, such as consenting to a marriage or consenting to sexual relations. There are certain matters to do with the Mental Health Act 1983 that the COP does not have jurisdiction over, and also rights to do with voting. As I said already, P must be over 16 in order for COP to have jurisdiction. And in the Court of Protection, it's usual for parties to be public bodies such as the local authority, relevant NHS trusts, family members, P themselves, and there are 3 tiers of judiciary. Moving on to the next slide. Here are the powers of the COP. I've set them out. There are multiple powers. Court of Protection can make declarations. It can make decisions or orders. It can deal with challenges to a standard authorization, only involving those over 18, of course, as I said. There are powers to do with deputies, including appointing and removing them. There are powers to do with lasting powers of attorney, advanced decisions, also enduring powers of attorney. The Court of Protection can make interim orders on the basis that there is reason to believe that P lacks capacity in relation to a particular matter. And of course, the Court of Protection has powers to gather information and can, for example, direct under Section 49 that a Section 49 report should be provided by a local authority or an NHS body. And finally, the role of Court of Protection in education matters. So education can come up in a number of different ways in the Court of Protection. I've already referred you to the case of GP, where the Court of Protection gave guidance on the relevant information that applies when you're considering whether or not P has capacity to make decisions about education. But education issues can come up, for example, in Dole's cases, where the Court of Protection is investigating best interest in terms of care and residents.
Sorry, Asma, can we just go to the next slide? Sorry, I think you're speaking about the next slide, but it hasn't moved on.
Oh,
thanks so much. Thank you.
Please, could we go on to the next slide?
No.
No.
Yeah.
What was the slide? Sorry, I'll just finish, Oliver, now. The other thing that I just wanted to flag on this point is that there are situations sometimes when the Court of Protection has directed local authority special educational needs teams to provide information or evidence directly to the Court of Protection. And a colleague mentioned that in one of her cases, the SEN manager was ordered to attend the Court of Protection to explain efforts that had been made to secure an education placement under the terms of the EHCP when P had been without education for some time. And so there are many circumstances when education issues can crop up, and that's everything I have to say, and I've run out of time. So thank you very much, Oliver. Over to Louise.
Thank you very much. Well, if we could turn to the next slide, I'm going to talk to you today about what to do if you think there is a capacity issue or there is a capacity issue and you are in proceedings before the first tier tribunal SEND in the special educational needs section. So the first slide we have here, I'm just setting out some of the relevant legal framework. In fact, in my view, these really are the points that you have to bear in mind. You have Section 3 of the Mental Capacity Act. Obviously, we have just heard all about that. Section 80 of the Children and Families Act, which you may be more familiar with if you are education practitioners. Regulation 64 of the SEND Regulations 2014. We also have the Code of Practice and the cases of Hillingdon and Buckinghamshire. Now, both of those cases were actually decided, as you'll see, on the same date. And they were both decided by the upper tribunal and deal with matters to do with capacity in exactly the same way. So to that extent, they were effectively conjoined on that issue. If we could now look at the next slide. So who does the issue of capacity apply to? Well, you're going to need to think about it in terms of young people, and it could, of course, also apply in terms of parents if they are the appellant in an appeal. Who is a young person? Well, it's somebody who's over compulsory school age, but under the age of 25. We know that from Section 83, which I've put there for your reference in the second bullet point. Section 51, of course, confers a right of appeal onto a young person. And it's Section 80 that deals with the young person who lacks capacity. And essentially what it does is adopt the meaning of lacking capacity that applies in the 2005 Act. And you can see that in subsection 5. It provides for references to a young person to be read as references to a young person's representative or their parent. And it is important when dealing with capacity issues to recognise that representative in the Section 80 sense is not representative in the sense that we more commonly use it. It doesn't mean an advocate. It has a very particular specific definition. And that specific meaning is set out under Section 80, subsection 6. And if we can just turn to the next slide, I have set that out there in full for you. Representative in relation to a parent or young person means either their deputy appointed by the Court of Protection, which you've obviously just heard about, or the donee of lasting power of attorney appointed by a parent or young person, or C, an attorney in whom an enduring power of attorney created by the parent or young person is vested. So it has a very specific statutory meaning, and it isn't to be confused with representative in the sense of, as I say, advocate. We can now turn to the next slide. There is a presumption of capacity. That is, of course, the fact that it is assumed that unless and until it is determined that a person doesn't have capacity to litigate by reference to the principles in the Mental Capacity Act, they are presumed that they can do so. Where there is phrases good cause for concern about a person's capacity to litigate, the tribunal should be ordering or considering making an assessment of that person's capacity. Any assessment should be conducted by reference to the principles of the Mental Capacity Act, which I'll refer back to what we've already heard from my colleague. If we can turn on to the next slide. So what to do when capacity is in doubt? Well, it is ultimately for the tribunal to determine whether or not an individual has capacity to conduct litigation. They need to do that by applying, as I've said there, the relevant sections of the Mental Capacity Act. In Buckinghamshire, the upper tribunal made it quite clear that it is a question of fact, ultimately, for the first tier tribunal to decide. And at paragraph 19, that judgment, they suggest that the most efficient way to resolve the issue, if indeed it is an issue, would be to deal with it as a preliminary issue. Tribunal have to decide before it, therefore, who the correct parties are. As what Section 80 essentially does is it allows for a statutory substitution of the person, the young person, without capacity for their representative. So, of course, therefore, it's going to be relevant to the issue of who are the correct parties to the appeal. As we will go on to see what happens if somebody doesn't have capacity and is acting by way of their representative or by way of their parent. We can now turn to the next slide. I wanted to emphasize that it's very much a consideration for all parties in an appeal. This isn't just for those who are potentially representing someone without capacity. All parties are going to need to consider it. That's part of the duty that sits under the overriding objective that requires cooperation. I've put the relevant references on the slide for you. And it would involve, certainly in my view, also drawing the issue to the tribunal's attention and providing the tribunal with any evidence it needs to resolve the issue, no matter which party to an appeal you are. If we can move on to the next slide. In Masterman and Lister, it was helpfully set out in respect of unrepresented litigants on the issue of bringing it before the court, that, as it was said at paragraph 17 there, sometimes doubts may arise in relation to an opponent acting in person, and that may be appropriate to bring the issue of capacity before the court. So that really just confirms what I've set out on the previous slide, that it may be, even if it is not the party you are representing or the party you are, where the lack of capacity is in question or capacity is in question, it may be appropriate still to consider the issue and to raise it. And I've put there a quote from the Equal Treatment Bench book that I won't read out to you, but essentially establishes what must be considered by the judge, court, tribunal when the party is not represented. And it suggests that the onus, therefore, is on the judge to investigate or consider if the person has capacity to conduct litigation as a matter of priority. And it stresses that concerns as to capacity to litigate may arise in a number of different ways, either in the court papers or also from the party's behaviour in court. However, it does suggest that embarking on those sort of inquiries needs to be done sensitively and, of course, with caution, due to the fact that, of course, there may be many reasons as to someone's behaviour, and also due to the serious and obviously serious nature and impact of any sort of capacity decision can have. If we can go to the next slide. So if you are in the situation where you need to consider capacity issues, what evidence do you need to consider might need to be put before the first tier tribunal? Well, perhaps ideally, a tribunal judge would wish to be faced with external expertise on the matter. And it has been suggested that courts might be slow to consider the capacity issue, make a finding on it without that sort of evidence, without some sort of medical evidence. And I've put a quote there that suggests, and I'll just read, due to shortness of time, I'll just read from the bottom of that quote, but suggestion in the case of Baker and Tilley, quoting indeed the Masterman and Lister case, the Carmarthenshire and County Council and Lewis case that I've already referred to, where the court said, I cannot think that the court can ordinarily, by its own impression of the litigant, safely form its own view of that. In other words, the issue of capacity. However, it doesn't always mean that you're going to need medical evidence. And if we could turn on to the next slide. In the case that I've set out, the first bullet point of Hindu and Hindu, the court made clear that it doesn't always require, there's not a requirement that you're always going to need medical evidence for the capacity issue to be determined. And again, Equal Treatment Bench Book does recognise that evidence could come, for example, from the carer or from social worker. And in the first tier tribunal, it may be that given the type of assessments that are taking place, there actually will be expert evidence that can deal with that, or certainly that an expert that could be directed to be or required to deal with the issue. But that, of course, may not always be the case, and it isn't necessary. But the point really is to think about the breadth of evidence that could be put before the first tier tribunal if they are having to make a capacity decision. If we can turn on to the next slide. So what does the first tier tribunal need to do if there isn't capacity, if an individual does not have capacity? Well, the first thing they need to do is make a finding as such. As I've said, it's the first tier the upper tribunal rather have confirmed that it's for them to make a factual finding on the issue. And then the appeal is to continue. There needs to be an alternative person appointed. I've put a short note there to suggest that usually decisions that are going to be made where there isn't capacity prior to the appointment of an alternative person or suitable person may be void. So it's of course important that this issue is dealt with as early in the proceedings as practical and possible. What is therefore an alternative person? Well, that is essentially set out under Regulation 64 of the 2014 regulations. Sets out what an alternative person is, or introduces the concept of and simply put, the young person's representative in the Section 80 sense is usually the alternative person if there is a representative, and that's under Regulation 64(2)A, and if not, under 64(2)B, then it is the young person's parent who will be the alternative person. If I can turn on to the next slide, where you then have an alternative person, they are the correct party to the appeal. They act in the capacity as an alternative person, but acting in the best interests of the young person. They are not acting on behalf of, as I've already said, they are not acting in the sense that an advocate does. However, of course, you could have both types of representative. An alternative person who's acting in a Section 80 representative sense can, of course, also rely on the services of a representative in the advocacy sense. In other words, they could have counsel, they could have a solicitor acting for them. In short, the last 3 bullet points I've set out make clear that parents still retain parental responsibility despite the fact that there is an alternative person. And if we can move on to the next slide, I stress the issue, and of course you've already heard, but capacity can fluctuate, and the relevance of that, of course, in terms of how you manage it in the first tier tribunal proceedings is that it must be kept under review. It may be that the issue arises not at the outset of proceedings, but actually as proceedings develop. And of course, it could be the capacity is at some point, there is capacity at some points, and there's a lack of capacity at other points. And it could well be that it fluctuates if a case is particularly lengthy or capacity is such that for some reason on the facts it changes with frequency. It may well be that you have to consider it at multiple points throughout the period of litigation. If that does happen, of course, you're going to need to ask the tribunal to substitute the party appropriately, depending on what exactly has happened. And then if I can ask you to turn on to the next slide, I also have stressed that, of course, capacity is issue specific, and it's the capacity to litigate the specific proceedings, the specific litigation that needs to be considered. And I set out there the quote, Mr. Justice Mumby in Sheffield County Council, that one has to focus on the particular piece of litigation in relation to which the issue arises. And so for those who haven't come across this before, don't frequently come across this and are acting in the first year tribunal, it is that lens. And I wanted to stress that. It's that lens through which the issue needs to be considered. I'm now going to turn, I'm conscious we're coming up towards the end of our hour, so I'm going to now turn to my colleague Oliver to give the third of our talks this evening.
Thank you very much. Thanks, Louise. Before I get going, I just wanted to mention that Asma cited a judgment by Mrs. Justice Roberts, a great judge, and we were all very sad to learn that she passed away on Monday, and may her memory be a blessing. She was a High Court judge for around a decade, and she was also a Court of Protection judge as well. So I'm going to talk about on the next slide, when a deprivation of liberty arises. This is a very complex area of law, and this is what I'm going to say is purely scratching the surface. It's just an overview. So when does a deprivation of liberty arise? The case law is developed from the case of Stork and Germany in 2005 in Strasbourg, and that has three requirements. The first is that P is confined, and the Supreme Court has said that that means that P is under continuous supervision and control and is not free to leave. So, for example, if they tried to leave, would the care staff prevent them from doing so? That's the first requirement. The second requirement is that there's no consent to that confinement. And the second requirement has three prongs, as it were. The first is that P has to have sufficient information to be able to make the decision in question. Secondly, that he or she gives consent voluntarily, so is not under any duress and is not being forced to take a particular decision. And the third prong, and this is the tricky one, whether P has capacity if they're over 16, because over 16 is when the MCA kicks in, or competence if they're under 16 to make the decision. And the third requirement in Stork is that the state is somehow responsible for the confinement. And again, this is a terribly overly complicated area of law, and that really doesn't do it justice, but you get a sense of what a deprivation of liberty is. Then what to do about it? How does a deprivation of liberty arise, or who can authorize it? Well, as we know, the first tier tribunal may make an order requiring, for example, a residential special school to be named in section I of a child's EHC plan, where it's obvious that the child will be deprived of his or her liberty, but the tribunal can't authorize the resulting deprivation. So orders of the tribunal are permissive rather than compulsory, and the parents aren't obliged to send their child to the school ordered if they make alternative suitable arrangements. And we think it's the local authorities' responsibility to ensure that the provision, if it is a deprivation of liberty per Stork, for that deprivation of liberty to be authorized using the appropriate procedure. And the appropriate procedure again, is very complex, and there's a smorgasbord of different types of procedure and court involvement depending on the precise situation. So some of the available options would include the following. So Section 25 of the Children Act, that's a secure accommodation order, and that can only be granted if the requirements of Section 25 are met, obviously. Then we've got a recent invention by the Family Division, and they have formed essentially an administrative branch, if you like, of the Family Division called, rather confusingly, the National Dole Court, where the Family Division can use its inherent jurisdiction, irrespective of a child's capacity, to authorize the placement of a child in an unregistered children's home or another setting. But even if it does make that order, it doesn't require the local authority to place the child there. The court, and we've done a few of these cases ourselves, the court may inquire as to why the local, or should inquire, sorry, as to why the local authority says that the placement into an unregistered placement is in the child's best interest, and the court may also require the local authority to inform the regulator of the child being placed in that unregistered placement. Then there's the Court of Protection, which you now know about, and the Court of Protection can authorize the deprivation of liberty of someone who is 16 plus, who lacks capacity in MCA terms. And the Court of Protection generally does that in a community setting. That can include a residential school, a family home, supported living accommodation, etc., etc. And then there's this now famous, or maybe infamous, phrase, DOLS, the deprivation of liberty safeguards. So DOLS is set out in Schedule A1 to the Mental Capacity Act, and it only applies in hospitals or care homes. And a care home in England, at least, must be registered with a CQC. And it only applies, as Asma has said, to adults, so 18 plus. And then what's not on the slide is something that was agreed by the previous or current government, Liberty Protection Safeguards. It's a statutory scheme whose entry into force was then shelved, and perhaps it's going to be resurrected by a future government. Worth also flagging, again, not on the slide, a Supreme Court decision in 2019 of Re D, and there the court held that the parental responsibility for a child who's 16 or 17 does not extend to authorizing the confinement of that child in circumstances that would otherwise amount to a deprivation of liberty. And so the implication of that is that the so-called ACID test, that's the continuous supervision and control and not free to leave duo, is likely to apply without modification to that age group, apart from the exception of life-sustaining emergency medical treatment. So next slide, please. I'm actually not going to say very much about restraints and other forms of restriction in school, because I've set out there what the relevant law and guidance is, but the overall picture is quite sad in England and Wales. Essentially, schools can use reasonable force and very, very easily justify it. And the evidence is that many children are being harmed. The vast majority of those children are children with diagnoses of autism and or learning disabilities. There's no current requirement on schools to even tell parents that this is happening, let alone inform a local authority or the regulator. And there's no current requirement on Ofsted, the regulator, to collect data about restraints and other types of restrictive practices in schools. Compare and contrast with the situation once a child turns 18 and maybe ends up in the mental health system, where the CQC, the regulator, the health and social care regulator, is all over this issue. So children get a much worse deal than adults, which is quite remarkable. Next slide, please. And I've set out here on this slide some sort of mini chronology of events that have happened. And essentially, the government had a consultation over a year ago now. Some of us at Doughty Street have been involved with Erwin Mitchell representing families and doing some political advocacy. We held a seminar again over a year ago, and the government published some research that it had commissioned. And next slide, please. Going to just end on these two reports. One that was published by the International Coalition Against Restraint and Seclusion report in England, and then Paris Hilton, who has very usefully come out and described her experiences as a teenager and has been at the forefront of advocacy. And so I really hope that any incoming government will prioritise the changing the legal and regulatory framework to much better uphold the rights of children, but in particular disabled children in the education system in this country. So thank you very much for attending and for listening, and we hope that you found it useful. Again, the slides will be sent out to you, and thank you very much for joining us this evening.